Hi everyone, good afternoon and thank you for joining us in our 2024 complimentary webinar series covering the FAR, or Federal Acquisition Regulations. We are coming to you live today from Washington, D.C., and we're glad you all could make it. Okay, so a bit about this series. As usual, all of our webinars are complimentary and recorded. The FAR has 52 total parts and we will run through them sequentially each week on Wednesdays and Fridays at noon Eastern Time. The recordings and PowerPoints will be posted within 24 hours of the webinar ending. You can find the recordings on our YouTube channel by subscribing to it using the link you see on the screen. There's no cost. You can find the PowerPoint on the SlideShare site using your LinkedIn credentials to log in. Again, there's no cost. We also offer sponsorship opportunities. If you're interested, please send us an email to hello@jenniferschaus.com. Okay, and now for how to sign up for this series. Unfortunately, there's no bulk registration, so you must register individually for each webinar. If you go to the Jennifer Schaus website, navigate to the section called the FAR, and you'll find the individual registration links. Also, the recording links will be posted here upon the completion of each webinar. Please note that we covered the FAR in 2020, so if you are eager to get a jump start, please find these historical recordings on our site. Navigate to the Webinars tab and scroll down to the section The FAR 2020. Because it has been 4 years, many of the regulations have changed and been updated, so please use this as a reference tool only. Okay, and a bit about us. We work with established federal contractors worldwide, helping them to navigate the market. Our services range from market analysis reports to contract vehicles and compliance. Some of the contract vehicles we support are listed here on your screen. For more information, please visit our website. Those are our services for federal contractors, but we also provide marketing and advertising services for organizations who are selling to federal contractors. We can add the extra muscle to your marketing efforts via our newsletter ads and webinar sponsorship to in-person events. Please email us and ask for a media kit. We are currently offering a discounted offer in our newsletter, which reaches over 34,000 subscribers. If you want to place an order or have any questions, please send us an email to hello@jenniferschaus.com. As you know, congressional hearings on both the House of Representatives and on the Senate side are open to the public unless otherwise stated. We have a list here of the upcoming schedule, including the date, time, building, and room numbers. Most meetings take place in the Dirksen, Rayburn, or Cannon buildings. If you are selling to any of these departments or agencies, attending the hearings can be a great way to gather information, understand the process, and also network with influencers. Please join us for our Summer Shorts webinar series this August. We will be hosting 30-minute GovCon webinars with industry leaders. The series runs every day for 2 weeks, starting on Monday, August 12th, and ending on Friday, August 23rd. Webinars will begin at 12 p.m. Eastern Time, and as usual, they are free to join. Both the registration and recording links can be found on our website under the tab Webinars. Here's a lineup for week 1. These leading ladies in the federal sector will cover various topics, including contract finance, contract management, capture, pricing, and compliance. And in week 2, we will look at capability statements, BD, marketing, subcontracting, and M&A. Please join us for these upcoming complimentary webinars with various Apex accelerators. Jennifer will be covering GSA schedules as well as federal marketing for a local Apex accelerator in Virginia. These are complimentary and online webinars, so please join us. She will also be teaching 2 classes for the Maryland Apex Accelerator, one on marketing and one on the GSA schedules. These are in July and in December, and once again, complimentary. She will also be speaking for webinars with the East Michigan Apex Accelerator. She will be covering GSA schedules and federal marketing, so look out for these dates in November and December. Our webinars are complimentary thanks to our longtime and generous corporate and in-kind sponsors. Please allow me to introduce them. We would like to thank our friends at GovEvents, the premier platform for posting events related to government and government contracting. You can find all of our webinars and our events at govevents.com, as well as recordings from our past 600+ webinars. We also want to thank Tom Johnson and his team at Set Aside Alert, the go-to publication for contracting opportunities for small, women-owned, veteran-owned, HUBZone, and 8A firms. Visit setasidealert.com for more information. The Fairfax Economic Development Authority has an online calendar of events and webinars. We want to thank them for posting our events and webinars on their calendar. The Virginia Apex Accelerator at George Mason University offers free one-on-one counseling to established government contracting firms in Virginia on federal, state, and local procurement topics. If you are interested in learning more, please use the links provided to explore their services, review homework recommendations, register for live training, and find useful links to agencies and other self-directed learning. One-on-one counseling is limited to eligible client companies. Appointment requests are handled in the order they were received and based on counselor availability due to high demand. Online resources and group trainings are free with no restriction on business location. Join the Greater Reston Chamber of Commerce's monthly GovCon Council meeting to network with peers, learn about upcoming events and opportunities, and help to shape future programming. The meetings take place the fourth Tuesday of each month at 8:30 a.m. at the Greater Reston Chamber of Commerce. The next meeting will be on July 23rd. Do you want help winning government contracts? Bitsby can help. Users can find contract opportunities for federal, state, and local government. Additionally, you can search for teaming partners, incumbent point of contact, expiring contracts, compliance matrices, and also proposal templates. Create your login today at bitsby.com. Bitsby is an official partner of the U.S. Small Business Administration's ETG and Power to Grow program. Events are the ultimate engagement channel to bring government and industry together. 68% of government personnel report that they attend more than one event each year. The Federal Business Council, or FBC, has worked with government and industry for 45 plus years to create gatherings where ideas are shared and to help government achieve its goals. This includes agency interest days, cybersecurity symposiums, technology expos, and offsite meetings. FBC provides full lifecycle meeting planning and event management. With over 5,000 meetings under their belt, FBC has the experience, systems, and personnel to make your next event exceptional. Learn more at www.fbcinc.com. Now, last but not least, please check out our friends over at GovBrew. GovBrew is the most read GovCon newsletter, keeping thousands of GovCon professionals in the loop with news, updates, and opportunities in the federal contracting market, all in a fun and accessible email that only takes 5 minutes to read. It's 100% free to join. It goes out every Monday, Wednesday, and Friday at 7 a.m., and it's filled with great content, event postings, webinars, and more. We encourage you to sign up at govbrew.co, or you can use the QR code you see on the screen. Another reason we're here today is to cover FAR Part 49. Let's meet today's speaker. Please welcome Liza Craig to the webinar. Liza, we're so glad to have you with us today and are excited to hear your presentation. I'll put myself on mute and turn the floor over to you. Just let me know when you want to get to the next slide.
Okay, wonderful. Thank you so much for this opportunity, for the warm welcome, and I was taking notes. Lots of great information for our folks that are out there in the federal contracting space. So thank you so much for all that you're doing on this platform. My name is Liza Craig, and I'm a partner at Goodwin Procter's Washington, D.C. office, and I lead the firm's government contracts and grants practice. I've been with the firm now a couple of years. Prior to that, I was at another large law firm in Washington, D.C., doing the same type of work in support of federal and state contractors and subcontractors. And prior to joining private practice, I worked for a number of years as a civilian attorney doing procurement, primarily for the Department of Defense, specifically the Department of the Navy. I enjoy talking to contractors, both prime and subs, about all sorts of issues related to federal contracting, supply chain, anything at all that impacts contractors as they are attempting to meet their customers' needs. And I'm really happy to be here today to talk a little bit about something that can be a little bit frightening for federal contractors, the terminations of contracts, basically covered under FAR Part 49. So let's jump right in and move to the next slide if we can. So when we talk about contract termination, before we get into the specific clauses, we're talking about simply one party's ability to terminate or end another party's obligations and responsibilities under a contract. So ending one's obligations under a contract. Now, the federal government, as most contractors know, is able to terminate its obligations via termination clauses found in FAR Part 49. And they can terminate at any point in time, either in part or in whole, at the convenience of the government. So just because simply the government wants to terminate, or alternatively, like we see in the private space or the commercial space, due to fault of the contractor. So the termination rights that the government has are regulatorily defined, statutorily defined. They are baked into the contract by these FAR provisions, and they really do give the federal government a very broad ability to terminate, again, importantly, for its own convenience, simply because it makes sense for the government to do so, or alternatively, because the contractor has done something that has placed it into default. Now, importantly, despite the fact that the federal government has these very broad rights that are set out by these FAR clauses, a contractor that is entered into a contract with the federal government and that is doing business with the federal government, providing either supplies or services has no right to terminate a government contract that is entered into. Again, important point, because for those that are new to the space, you may be thinking about, well, what if the government isn't living up to its end of the bargain? The government is not doing what it agreed to do when we entered into this contract. If we were in the commercial space and this were not the federal government, the contractor might have a right to initiate terminations or to pull out of that contract. But unfortunately, when a contractor is doing business with the federal government, that right does not exist. Important note to remember whenever you're dealing with the federal government. Next slide. So FAR Part 49, what we're here to talk about today, really establishes the policies, the procedures, provides guidance for contracting officers that find themselves in a situation where they need to end a contractual relationship with a contract. They provide, FAR Part 49 is going to provide information for contracting officers that will help them make a determination whether or not a contract needs to be terminated in whole, whether or not it may need to be terminated in part, and what it needs to do, what the government needs to do if it finds itself in a situation where it needs to terminate a contract for its own convenience or simply because of performance issues with the contractor. It also prescribes contract clauses that relate to termination and excusable delays, and it includes a number of instructions that the contracting officer must use relating to settlement forms, because the settlement contracts and the settlement agreements become a very important part of contract termination, as we will continue to discuss. Now, I raise these, I speak a little bit about, these are a lot of guidances and a lot of information available for the contracting officer. But for those of you whose businesses are engaged with the federal government, I would encourage you to take a look at FAR Part 49 to familiarize yourself with the information that the government uses when they find itself needing to navigate this space. So again, even though a lot of this information sets forth the rights of the government, the obligations of the contractors, and provides these prescriptive instructions and methods and procedures that the contracting officer must use, the more you as a federal contractor understand the process, the more you're going to be able to navigate the process should you find yourself in this situation. Next slide. Now, as I mentioned, the procedures for terminating a contract will vary depending on whether the contract is being terminated for the government's convenience or due to the contractor's fault. Not only will the procedures vary, but there will also be different remedies available to the contractor depending on what situation they find themselves in. The FAR also makes a distinction between what the government can do and what the government should do, depending on whether the contract that is being terminated is a commercial contract or a non-commercial contract. So again, it's important for you to realize, if you find yourself in this situation, exactly what category you fall into. Are you providing the government with developmental services, specially tailored supplies that are not commercially available? If so, depending on convenience or termination for default, the government's going to approach that a little bit differently than if you're providing commercial services or commercial supplies. And we'll talk about that a little bit as we move forward this afternoon with our discussion. So next slide. Now, these three terms I think are really important to sort of highlight. And it's amazing to me in my practice the number of times that very seasoned federal contractors, subcontractors, even contracting officers and attorneys that are working in the space get these terms confused. So I wanted to highlight the three different types of termination rights that are available to the federal government, and talk a little bit in setting the stage about the difference between the three. So the first we're going to talk about is the termination for convenience, also known as a T for C. Now, this is when the federal government decides to terminate either a commercial or non-commercial contract for its own convenience. So we'll talk a little bit more about that. But again, takeaway, termination for convenience, commercial or non-commercial contract is going to come to an end, either in whole or in part, simply because the government wants to end it, and absolutely because of nothing that the contractor has done. The second type of termination that we want to talk about is the dreaded termination for default, or T for D. Now, a T for D occurs when the federal government terminates a non-commercial contract based on some sort of action or inaction on the part of the contractor. So the contractor has done something that has breached one of its obligations under a federal contract, and the contractor has been providing these non-commercial supplies or services. A termination for default is potentially on the table. Finally, the third important category of termination that we want to discuss today is known as termination for cause. This is when the federal government terminates a commercial supplies, commercial services, due to contractor fault. So again, as we sort of move through this, remember those three terms: termination for convenience, termination for default, and the termination for cause. We'll talk about all three in detail, but it is important to remember that depending on what type of work you're doing for the federal government, and depending on why the government may want to terminate you, there may be some slightly different procedures and remedies available to the government, to the contractor, and protocols that will apply. Next slide. All right, so let's dive in a little bit to termination for convenience. In this particular case, we're talking about the government's unilateral contractual right to either partially or fully terminate a contract without being required to pay damages. And here's the key. The government has the right to do this even when the contractor is fully performing, even when the contractor is doing everything right, delivering on time, providing the government exactly what it needs it's on contract to provide them with, no issues at all in terms of performance. Now, the FAR defines the exercise of the government's right to completely or partially terminate performance, specifically when it's in the government's interest. And it's this provision here, the T for C, is one of the most unique provisions of government contracting. There really is no counterpart in common law contracting. And again, a lot of folks that are new to the federal contracting space are sometimes quite surprised that the government is given this right and that this is a clause that appears in every single contract. So as I said, the government doesn't really need any particular reason to terminate a contract for convenience other than it simply is in its best interest to do so. Let's move on to the next slide. So I mentioned at the very beginning the FAR providing in section, in Part 49, templates and information about settlement agreements. So what happens when a contracting officer decides to terminate for agreement for convenience? They're allowed to enter into what's known as settlement agreements. Now, before we get to the settlement agreements and talk about that a little bit more, I want to highlight that a contracting officer, by regulation, is only permitted to move forward with the termination for convenience when there has been a written determination that it is in the government's best interest to do so. Now, you can imagine a termination for convenience, the ending of a contract that a contractor has relied on, is a pretty significant undertaking. And so the government really needs to do its due diligence and make a determination that it is in the government's interest to take this extraordinary step before it simply moves forward. And that's the sort of protection for the contractor, so that the government is not entering into contracts, allowing contractors to rely on the revenue, rely on the opportunity to provide these goods and services, and then simply on a whim being told contract is done, we're walking away. So again, that requirement for the contracting officer to determine that it's in the government's best interest to terminate is extremely important. Now, when making that determination that the termination for convenience is in its best interest, the contracting officer has to consider alternatives to termination because, again, remember, the contractor hasn't done anything wrong. And they have to confer with the end user, the customer that's being supported by the contract, with their own legal advisors, and other interested parties, including the contractor. So again, if you ever find yourself in the situation where your contract is being terminated for convenience or the government is proposing that, you should be able to get information about this robust consultation process that should be occurring. It's not something that a contracting officer does in a vacuum. Let's see. Yes, and of note, the FAR specifically requires that if a contract has been performed and there is a balance on the contract less than $5,000 remaining, that the government is normally should allow that contract to be permitted to run to completion rather than termination. And again, that small amount sort of recognizes that a termination can be expensive, a termination can be difficult for the contractor. And so if the contract has pretty much been fully performed, that consultation is most likely going to result in the government not being able to terminate the contract, but really to allow it to continue. So next slide. Now, importantly, when a contracting officer terminates a contract for convenience, a contractor is going to be allowed to recover certain elements under that contract, specifically profit on any preparations made and work done for the terminated portion of the contract. So I'm a contractor, I'm preparing to continue to deliver these supplies under the contract, and I get a notice that the contract needs to be terminated for convenience. The contracting officer goes through this consultation process, realizes that this is appropriately for the government's convenience. I'm going to be allowed profits on the work that I did to prepare for delivering that the portion of the contract that is going to be terminated. However, settlement expenses, anticipatory profits, so profits I thought I was going to make or I had not yet realized, and consequential damages are not allowed. So important, if you find yourself in this particular situation, to pay close attention to the FAR to understand what you will be allowed under a T4C situation and what specifically will be excluded. This information all gets resolved and sort of reduced down to the settlement agreement that I mentioned, where the government is going to agree to make the contractor whole in certain areas because they have elected to terminate the contract for its convenience. So important to just be aware of that. Now, in the event that the government and the contractor cannot come to an agreement about how the elements related to outstanding costs, profits being owed to the contractor, any of the information remains in dispute, the government has the right to enter into what's known as a settlement by determination. And this is a unilateral settlement determination that will be issued when the government and the contractor cannot reach a bilateral agreement. So this, again, the contractor, it'll within 30 days, I believe, of when the contracting officer determines that resolution cannot be issued, the contracting officer can move forward and do a settlement by determination, which will give it some finality. Let's see. What else I want to say on this one? Okay, let's go on to the next slide here, and let's move on to termination for default. Okay, so as I mentioned earlier, termination for default, this applies to non-commercial contracts only. Now, this resembles a common law breach of contract, and this is really when the contractor, the entity that's doing business with the government, has failed to live up to some of its obligations or has somehow defaulted and put itself in a situation where the government is saying it is not performing. Now, the federal government is entitled to a number of various forms of damages from the contractor's relief. And in addition to being able to recover in these areas, they can also charge the contractor for the additional cost associated with reprocuring the supplies or services. So termination for default can be very expensive. Unlike the termination for convenience, where the government is working with the contractor to try to not harm the contractor, in this particular case, the FAR allows the government to really exercise its full rights to not only make sure that it's made whole, but it also gets the contractor to support it in being able to reprocure the supplies or services that the contractor failed to supply. Now, when considering a potential termination for default, again, just like in the termination for convenience, the contracting officer should be coordinating closely with its customers and end users, and it should be consulting with legal counsel. A termination for default is not something to be taken lightly, and there should be quite a bit of interaction, quite a bit of communication prior to this extreme action taking place. Next slide. All right. So what should the contracting officer consider when determining whether or not a termination for default is appropriate? I've got a number of bullets here, and I think it's important to walk through them. Contracting officer should be thinking about the terms of the contract. What did the contractor breach? What did they fail to comply with? How material were the terms of the contract that the contractor did not meet? They should also be looking at the specific failure, the specific breach, the shortcoming, and the reason for the failure. Is there a good reason why the contractor couldn't meet its obligations, or is the reason simply not excusable or not justifiable? Contracting officer and the government may also be looking at the availability of the supplies or services from other sources. I raise this because it's an important one. If the contracting officer is going to terminate a contractor for default, if they truly need these supplies and services, are they going to be able to readily get them from another source? Sometimes that can be complicated, and sometimes that might inform the government's decision as to whether to move forward with the termination for default or to continue to work with the contractor to try to cure the issue. In that same vein, the contracting officer should be looking at the urgency of the need for supplies and services and what period of time or what amount of time it would take for the government to actually go out, reprocure, resolicit from other sources, as compared to what it would take to help the contractor that they're currently in privity with cure their default and perhaps be able to come out of a stage of delinquency. So again, how urgent do we need this? Do we have the time to continue to work through a cure? Do we have the resources as the government to continue to work with this contractor to help them cure the default? That's something that often the government is taking in place. The degree of importance of the contractor in the government acquisition program and the effect of the termination for default upon the contractor's capability as a supplier under other contracts. Now, this one's a little bit unique, but I often saw this as a DoD procurement attorney. We had contractors that were providing very technical solutions or very technical supplies, normally related to weapon systems or defense systems. And so there was a question, if one contractor is pulled out of the acquisition community because of a default, which can have some pretty significant consequences, is that going to effectively wipe a supplier off the map? What is that going to do in terms of the government being able to get some of these sensitive supplies or solutions if a critical contractor is terminated for default and no longer can do business with the government, which sometimes occurs. So that's something that the contracting officer will consider. As well, there are other relevant facts and circumstances that the government wants to look at. So my takeaway here for everyone listening in is a termination for default can have some pretty significant consequences. But again, it is very important that the contracting officer take a close look at a number of these factors before moving forward with the termination to make a decision as to whether or not termination for default is in the interest of the government and is appropriate based on whatever default or lack of compliance that the contractor has engaged in. Next slide. Now, if the government contracting officer goes through those considerations and determines that a termination for default is appropriate and they need to move forward with that termination, the contracting officer has to notify the contractor in writing of the possibility of this determination. Very important. So the notice should set forth the contractor's contractual liabilities and obligations under the contract and request the contractor to show cause why the contract should not be terminated for default. Normally, your show cause letter that the contracting officer will issue basically puts you on notice. It says, hey, look, this may be coming. You've got these obligations under the contract that you're not meeting, or you're in danger of breaching, or maybe you've already breached them. You need to let me know why termination for default is not appropriate. Contractor will have an opportunity to respond, and this notice may certainly let the contractor know that if they don't take the show cause notice seriously and do not respond within a certain period of time and provide an explanation, that the failure to respond may be taken by the federal government as an admission that no valid explanation for the default exists and that a termination for default is appropriate. Next slide. Now, the government, if a contract is terminated for default, unlike for convenience, they're not liable for the contractor's costs related to any undelivered work. And the government actually may be entitled to any repayments related to advance payments or progress payments if they've been made. So it's important, if you find yourself in this situation, to take a look at the structure of your contract, how you've been paid, to know not only whether or not you're going to be liable for reprocurement costs, or whether or not you actually may owe the government if they've paid you any monies in advance to get the work done. Now, the contracting officer may also elect to require the contractor to transfer title to any supplies and deliver to the government any completed supplies or manufacturing materials. And the point here is, again, the government needs to get these products or services delivered. And so they may take what the defaulting contractor has done so that it can transfer it over to another legal entity that can continue to complete the work in a timely manner and deliver ultimately to meet the government's needs. So quite a few consequences that can result here. What I don't have noted on the slide that I do want to point out as well is, in addition to the financial consequences and impacts of a termination for default, you also can have a contractor, depending on why they defaulted, being subject to exclusion from doing business with other government agencies or entities. Normally, a termination for default can have very wide-ranging consequences for a contractor, and perhaps even put a contractor in the position of being unable to do future business with the government until whatever issues that gave rise to that default have been resolved to the satisfaction of the federal government. So if you find yourself in a situation where you're being terminated for default, important to know that it's unlikely that any other current contracts that you're performing will be impacted, although there's always that possibility. But certainly there's a very real impact that any future work could certainly be impacted by a termination for default that is allowed to go through to its to its natural end. So not a good place to be in. Recommendation would always be, if you find yourself in a situation where you're being notified of a termination for default, to work with outside counsel or in-house counsel to make sure you understand your obligations, your rights, any potential remedies that may exist, and make sure that you've got support navigating this process, not only for the financial implications, but as well for the legal implications that could impact your future business. The next slide. So moving on, talk a little bit now for the third category of termination that is under this section of the FAR, and this relates to the termination of cause, the government's right to terminate a commercial contract for cause, and this relates to if the contractor has failed to either provide the government with its supplies or services, they have not complied with certain contractual terms or conditions, and also if the contracting officer has concerns that there are future issues related to performance. Perhaps the contracting officer is concerned that while the contractor may be providing these commercial services or commercial products now, there's a concern that they're not going to be able to complete the contract. They're maybe not going to be able to continue to deliver in the out months or in the out years. And so if the contracting officer is asking for assurances and the contractor is not able to provide those, this may give rise to a termination for cause. Again, can be a pretty dramatic situation for a contractor to find themselves in. Next slide. Let's see. Now, when a contracting officer is thinking about terminating for cause, as in all of these termination provisions, I want to make sure that you understand that that this is the contracting officer's ability to terminate either the entire contract or even a portion of the contract. And so again, the FAR gives the contracting officer quite a bit of flexibility here to make a termination decision based on really the specific circumstances related to the contract itself. So you may have a company or contract that is partially been performed, no problems there. But again, as I mentioned, the future performance is in question. So you might wind up in a situation where the government elects to do a partial termination for cause that could affect a portion of the contract. Next slide. Now, again, we've got a cure notice concept that comes in when you've got a termination for cause that is on the table. So the contracting officer must send what's known as this cure notice prior to terminating the contract. The cure notice must be in writing, and it should describe any failure or concerns that the government has with the contractor's performance and provide the contractor with a period of 10 days by which the failure can be cured. So again, there is a period of time here baked in for the government to put the contractor on notice that there's a problem, ask the contractor point of contact to engage with the government about how they're going to cure this deficiency or failure. And there's a 10-day window there. Would always be encouraged if you receive a cure notice from the federal government related to a termination for a commercial contract for cause, important to timely respond, because a failure to do so may be taken as the government's admission that there is a true issue and that a cure is not possible. Next slide. Now, there's also a show cause notice that is contemplated under a termination for cause as well. And the show cause notice is issued by the contracting officer when there really is not sufficient time remaining in the delivery schedule to cure the problem, or if the contractor has failed to act on a previously supplied cure notice. So again, responsiveness is critical if you receive a cure notice. Now, the show cause notice will advise the company of the consequences of a termination and ask the contractor, much like we saw in the termination for default, to show cause why the contract at this point in time should not be terminated in whole or in part. So again, you normally would receive the cure notice, and if the cure notice either doesn't satisfy the contracting officer or is not responded to, or there simply doesn't appear to be time for any sort of course correction, you'll see that follow-up that will be that show cause notice. Importantly, though, I do want to point out the show cause notice, though, does allow for another opportunity for engagement. So again, the contractor can engage and should engage with the contracting officer to try to prevent ultimately the termination of cause of this commercial contract. Next slide. Now, importantly, if the government determines after the engagement through the show cause letter and the cure notice that termination for cause is appropriate, the federal government is not liable to the contractor for any amount. So unlike termination for convenience, when the government will engage and try to get into a settlement, termination settlement agreement, it doesn't happen here. The contractor is liable for any and all rights and remedies provided by law. So the government can come after the contractor if the contract needs to be terminated for cause for any obligations or any liabilities under that contract. Now, when the supplies or services are still required after termination, meaning a contract is terminated for cause during the course of contract performance, the contracting officer can certainly elect to go to another source for the same or similar supplies or services. And similar to the situation in a termination for default, the contracting officer on behalf of the government can recover from the contractor any excess procurement costs. So termination for cause can be pretty significant because not only is that lost revenue for the contractor who's had the contract terminated, they could be on the hook for reprocurement costs to the extent that the government has them to meet its needs. So again, pretty significant. Next slide. So takeaways. And we could have gone a lot deeper, but given the amount of time and the amount of information that we've provided, my first takeaway would be because these specific termination clauses will exist in your contract, will exist, not negotiable. You can't negotiate these out. It's important to familiarize yourself with FAR Part 49 and important to really familiarize yourself with the nuances for these three types of termination provisions and understand which may apply to you depending on the work that you're doing for the federal government. So I would encourage you to review the specific termination clauses as well in your prime contract to ensure that you understand what the triggers may be, and also to ensure you understand that if you find yourself in the unfortunate situation of being on the other side of a termination, you understand what the contracting officer is required to do and what processes need to be followed. If the government needs to notify you via a show cause or a cure notice, make sure that you're getting those. Make sure that you're looking out for those communications and make sure that you're responding in a timely and in a proactive manner. Take advantage of that engagement. Communicate with your contracting officer if you encounter any performance issues that may put you or your contract at risk for termination. You may not be able to do that with a termination for convenience. Obviously, it's not your fault. But even if you've got insights from your customer, you've got insights from your points of contact within the federal government that a termination for convenience may be considered, start engaging with your CO early and often about that and see if you can mitigate that. Of course, again, if you find yourself in a situation where you may be subject to a termination for default or termination for cause, certainly communicating about performance issues early, often. If continuing the contract is something that your company wants to do, trying to work with the government to avoid termination and to get the contract back on track in terms of delivery and performance is always ideal. And you need to make sure that your communication efforts have that goal in mind. Again, I will say respond to all written notices promptly. If the government contracting officer is reaching out to you in writing, reaching out to folks in your contracting shop or in your contract management shop, make sure that those notices are being received. Make sure that they're not being lost in people's inboxes. Make sure that they're not being filed away and dealt with, at the end of the week. Respond promptly. The clock is ticking, and in many times a failure to respond can put you in a default situation. You don't want to be in that situation at all. And finally, a reiteration of what we like to say, CYA has a number of meanings depending on how you want to look at that acronym. But in this particular case, I will say consult your attorney if you find yourself facing contract termination of any of the types that we've discussed today. A lot of times your attorney can assist you with responding to government inquiries and government requests for information, and also can help you understand your rights and obligations under the FAR and pursuant to your contract if you find yourself in this situation. A competent counsel can also help to minimize the impact that any unfortunate termination might have on your current business with the government, and most importantly, any future business, minimize reputational harm, ability to continue to contract with the government, may even be able to, in fact, help you navigate past performance issues that may arise, past performance blurs that may wind up on your past performance record that can affect your future business. So again, being able to consult with competent counsel, whether in-house or outside, becomes really important here in the Washington, D.C. area. You've got a lot of great choices for legal counsel, and so make sure that you avail yourself. And with that, I'm going to wrap up today. Again, my information will be provided in the slide deck, and so certainly if you need to speak with me, I'm happy to do so about anything that I've discussed today, as well. I'm also a member of a very robust legal community here in Washington, D.C., and I'm always happy to connect you with the right attorney or right legal counsel specifically for your specific needs. So I'd like to thank Jen's organization today for allowing me to speak with you all about termination, and appreciate the opportunity, and again, hope to be able to come back to speak with the audience again in time on other issues of importance to federal contractors. Thank you so much.
Thank you, Liza, for such an informative presentation, and thank you to everyone who joined us today. As mentioned, you can always catch the recording on our YouTube channel within 24 hours, and you'll find over 700 webinars on government contracting there. That's it for today. Thank you, Liza, and thank you to everyone who joined us.
Thank you so much. Have a great day. Bye-bye.